the society, Secretary Mihir Sheth, seniors in the profession, and friends. I sincerely I welcome all of you to this lecture meeting. I welcome today's speaker, CA Padamchandji Khincha, and thank you for accepting our invitation. I sincerely thank past President CA Dr. Mayurbhai Nayak for his initiative and fast action for today's lecture meeting, and a managing committee member and International Tax Committee convener, CA Rutvik Sanghvi, for his help. Friends, BCAS is a voluntary body of chartered accountants with 73 years of presence. It's a long time for a voluntary body to be in public domain and being relevant. One of the achievements of BCAS is its ethical and governance practices with quality benchmarks. BCAS always tries to remain ahead of the curve, and these inherent qualities facilitates us to get the best faculties, best subjects on BCAS platform, and the faculty share their knowledge, their experience and expertise here. And BCAS knowledge sharing efforts adds value to the participants in different ways, and they come back to us sometimes even after 35-40 years and express their krutadnyata with generous words, with moral and physical support, with financial contributions, and so on. Obviously, it is their choice. It is a real moment of satisfaction for all of us at BCAS, and we feel proud of credibility and the traditions of BCAS. It makes us humble and encourages us to move forward with much more enthusiasm, coupled with higher responsibility. Software taxation in a domestic law under DTAA, under international tax, is always a subject matter of debate and litigation. Recently, in first week of March, Supreme Court, in the case of Engineering Analysis Center for Excellence Private Limited versus the Commissioner of Income Tax, delivered a judgment on important aspects of software taxation, royalty, etc. The bench delivering the judgment consisted of Honorable Justice R.F. Nariman, Hemant Gupta, and Mr. B.R. Gawai. We felt CA Padamchandji Khincha is the right person to help us analyze this judgment and understand the nuances. He himself is based in a software city of Bangalore and is an advisor to Indian and foreign software giants, and is a very dear friend of BCAS. He makes himself available at a phone call away or at an email away in spite of his extremely busy schedule. So we thank you for the same, Padamchandji. And with these brief remarks, I welcome you again and wish you an enriching experience with the speaker today. May I request Secretary Mihir to introduce the speaker formally. Thank you.
Thank you, Suhas. Ladies and gentlemen, we have a very distinguished faculty, and I sincerely believe that the 2 minutes of this introduction of Mr. Padamchandji Khincha is not enough to really justify the great work that he has done. But let me make an honest attempt. CA H. Padamchand Khincha is a partner in HC Khincha and Company and HC Khincha and Associates, Bangalore. With over 30 years of experience in corporate and international tax regime, he has spearheaded the income tax consultancy and litigation practice. He advises multinational companies, Indian companies, as well as high net worth individuals on various tax matters, including tax structuring, due diligence, transfer pricing, and compliance aspects. He has represented large corporates in some of the high-profile cases before various income tax tribunals across India and has been associated with several landmark decisions. CA Padamchand Khincha is a prolific writer on various topics on income tax. He has authored the book Emerging Issues in International Taxation. He has co-authored Decoding Section 5, Tax Holiday under Section 10A and 10B, an analysis, Tax Treaties of India, a compilation, Capital Gains of Non-Residents, Tax Deduction at Source, Concept of Indexation under Capital Gains. He has contributed to 101 Supreme Court landmark judgments published by the Chamber of Tax Consultants. He has authored and co-authored innumerable articles across various tax magazines, including the Taxman publications, Bombay Chartered Accountants Journal, ITR, etc. He has delivered more than 500 lectures across the nation on several income tax issues and has been actively engaged in several initiatives undertaken by the Institute of Chartered Accountants of India. He was appointed the group leader for preparing the approach paper on guidance note on transfer pricing. He was instrumental in making a critical analysis of the direct tax code as a member of the team constituted by ICAI on the request of CBDT. He currently is a member of committee of ICAI involved in preparing the technical background paper on income computation and disclosure standards. He has deposed as an expert before a high-powered committee on e-commerce constituted by the Central Board of Direct Taxes in India, Rangachari committee set up to review taxation of development centers and the IT sector, by the AP Shah committee constituted by the Government of India to examine the matters relating to amity on FII FPIs. He has been a country reporter for India for IFA Rio de Janeiro Congress 2017 on assessing BEPS origin standards responses. He's on editorial board constituted by the International Tax Journal published by the Chamber of Tax Consultants. His teaching stints in the past includes guest lectures at IIM Bangalore, intensive coaching classes of ICAI, faculty at the Direct Taxes Training Institute of the Income Tax Department. Padamchand Khicha is a commerce graduate from the University of Bangalore, securing 5th rank at the university level. He holds a bachelor's degree in law. He qualified as a chartered accountant in 1982 by securing the 25th rank. Thank you for honoring us, Mr. Khicha, as always, and over to you for your address. Thank you very much.
Suhas Bhai, Mir Bhai, Mayur Bhai, Rutvik, and distinguished participants. I thank the Bombay Chartered Accountants for inviting me here, the privilege granted to come and address the members. But more importantly, I thank the Bombay Chartered Accountants for mandating this learning exercise. Invitation from a Bombay Chartered Accountant to talk means you necessarily are compelled to devote significant time. And I've attempted to do that. I thank the Bombay Chartered Accountants for this opportunity given to learn about a subject, discuss, deliberate, and then share. I have learned because of my deliberations and discussions with a lot of people, with Ganesh Rajgopal, with Chaitanya, with SRS and others. And I am therefore going to be some sort of a representative of the cumulative of thoughts that I've gathered from these discussions and the study I've made. And therefore I said, thanks to the Bombay Chartered Accountant for giving this wonderful opportunity of learning and sharing the thoughts of mine. We are to discuss today the landmark decision of the Supreme Court in the software case. If you look into the history recent times, many discussions have happened. Many organizations have already conducted meetings, and therefore the question arises, is there a need? Are we therefore too late in the day to discuss? In my opinion, the fact that many discussions have happened does not preclude a newer discussion, a further discussion. That's because this topic is very fascinating. This topic is very formidable. Many disciplines are involved. You look at the Income Tax Act, you look at copyright law, you look at so many other enactments. The Supreme Court also went into the customs law, went into the Sale of Goods Act, went into so many other laws also for the purpose of coming to a conclusion. It also went into a number of copyright decisions for the purpose of expounding the meaning of various terms relevant for the purpose of rendering this decision. Therefore, many disciplines are involved, and therefore it involves a multi-dimensional approach for us to understand as to what the decision means to a lot of people. Therefore, no discussion when there is a situation of interdisciplinary approach required of a very fascinating and a formidable topic. In my opinion, no discussion can exhaust all angles of a study of this decision concern. And therefore, it's appropriate for us that we spend time again to understand what this decision means. It's also important for us to understand and appreciate that the Supreme Court was concerned, if you look into the start of the decision, 4 types of transactions. 2 types of transactions concerned the distributors, whether he was an India distributor or he was a foreign distributor selling to somebody else in India, or he was the end user, or the software was a component of a hardware. There were 4 different situations that the Supreme Court dealt with. Out of these 4 situations dealt with by the Supreme Court, rightly or wrongly, did not pronounce on the 4th aspect or the 4th category. What happens when a software is bundled along with a hardware component? Those were not the facts before the Supreme Court. Although the Supreme Court did make a mention that we are classifying or bunching these categories into 4, there is no occasion for the Supreme Court to deal with the aspect of software when it is an integral part of the hardware. But the answer to that question is possibly easily available by the second proviso to 916, which says that when you have a software, which there is a transfer of all or any rights in relation to a software, but that software becomes a necessary accompaniment of a hardware, then this will not be regarded as royalties, largely because circular number 202 said this is going to be regarded as goods, and we are liable to pay customs duty. We don't have at the same time a charge for royalty in relation to such type of a transaction. And therefore, possibly the law itself did give us a clue or a solution in relation to software, which is embedded along with the hardware. But what remains therefore for our discussion is the aspect of an end user and the aspect of a distributor. Under what circumstances the payments made by the end user or by a distributor will tantamount to royalties. And as you have seen, therefore, there are 3 types of cases that the Supreme Court was concerned with, but that does not exhaust the various type of transactions that can be entered into in relation to a software. For example, if the owner of the copyright himself creates copies, brings them himself into this country and then sells, what happens? Possibly, you may not have the decision of the Supreme Court covering that aspect because the facts of this nature were not there before the Supreme Court. And therefore, there are many type of rights, many type of transfers involved. And what Supreme Court has discussed in this decision does not necessarily exhaust all the type of transactions that can be accomplished in a software. Therefore, it becomes essential for us to understand very closely what is the heart and soul of this decision. And when we have understood the heart and soul of this decision, then we can possibly find answers to various other type of transactions that may be involved in relation to this software transactions. What's also important to understand and notice is that many new studies are being done today. For example, the UN is coming out with a significant amount of study on transactions related to software and what should be the approach in relation to software, whether it should be part of royalty. And if it's to be regarded as part of royalty, how should we go about and achieve that by amending the definition of royalties under the Model Convention? We also have a study by the OECD on automated digital services in the context of Action Plan 1, digital commerce, and the Pillar 1. Therefore, the attempt today is therefore to look at software being regarded as part of the automated digital services such that there could possibly be some sort of a withholding tax as a final levy when a payment is made under a transaction involving the software or a use of software. We've had the Income Tax Act being amended a couple of years ago to say that software, a download of software shall give rise to a business connection under the concept of significant economic presence by explanation 2 capital A being introduced. Therefore, we have a situation where a download of software can be regarded as giving rise to a business connection, possibly something that was thought to be placed separately and distinctly from the existing definition of royalty. We have an equalization levy, and therefore we have some transactions of goods and services through an electronic platform. The digital services giving rise to an equalization levy. We have to understand as to what will happen in relation to equalization levy. We've had certain changes to the indirect taxes because the understanding under the service tax was different. The understanding now under the CGST in relation to transaction and software are different from what was the understanding under the service tax law. Therefore, what's happening is we are seeing a flurry of activity or action in relation to software because the government is concerned to adopt multiple or diverse approaches. And these diverse approaches are not giving rise necessarily to a convergence. They are showing a attempt or a effort in a disjointed manner. But then that shows the eagerness of the government to ensure that some portion of tax is at least levied rightly or wrongly, somewhere the other, directly or indirectly on software transactions. And therefore, it becomes essential for us when Supreme Court was discussing only 3 aspects of transaction, what will be the ramifications of Supreme Court decision in relation to all these transactions of equalization levy or SAP or automated digital services, what happened under the UN model. It becomes very interesting for us, therefore, to understand the principles and find out how will these principles be relevant for these new topics and this new study that have happened now. Importantly also, one has to understand what shall be the import of this decision under the copyright law itself. We are not dealing with copyright law today, but it will be significant to understand as to the meaning of infringement, the meaning of the various type of causes of action that can give rise to violations and compensations for the owner, for the exclusive licensee. Therefore, would this income tax decision have a bearing under the copyright law itself could be very interesting. That may not be a subject matter of our discussion today, but what's important for us to understand is that this decision throws out certain principles, and those principles possibly will have a bearing because the Supreme Court itself has decided and referred to a number of copyright decisions, and therefore they have taken out the principles thereunder to drive home the principle for the purpose of Income Tax Act. Therefore, possibly a reverse flow of the logic from the Income Tax Act to the copyright law appears to be inevitable. That will be a very interesting case for us, and therefore we will have to have an occasion to understand the implications of the Supreme Court decision in relation to the copyright law. What's also important for us to understand is that one finds in recent times a very clear wedge between the approach of the OECD Model Convention and the approach of the UN Model Convention in relation to taxation of software. And that divergence is increasing. And therefore, there's going to be some sort of a pull and push between the OECD model and the UN model, ultimately in terms of finding out what shall be their recommendations, what shall be their final output in relation to taxation from or out of digital transactions. And therefore, one also is finding that as a result of these studies concerned, many countries are adopting unilateral solutions for finding out how to best get out of or best get the taxation out of this digital transaction. And therefore, this type of a nuance, this type of a divergence, this type of variation gives rise to a fascinating study of the implications of this software Supreme Court decision. It's important for us, as far as tax law is concerned, to go into 916 and say, what does 916 tell us? But before I go to 916, I thought it was appropriate that we have some sort of a bird's eye view of the copyright law, because ultimately 916, Limb 5 particularly, makes a reference to the copyright law. And it will be important for us to look into certain provisions of the copyright law, understand those provisions, understand the legal effect of those provisions, and having understood the legal effect of those provisions, we will then transpose them or those legal conclusions into the Income Tax Act for the purpose of understanding as to what shall be the implication under the Income Tax Act. Para 33 of the Supreme Court decision talks about and extracts certain sections of the copyright law. In my opinion, these are extremely relevant. They refer to 2 definitions largely. 2J, that refers to an exclusive license. 2M, that refers to an infringing copy of the software. And they refer to sections 14, section 16, section 18 and 19, section 30 and 30 capital A, section 51, 52 in one bunch, 54 and 58 in another bunch. I have referred to these sections by numbers. We'll have an occasion to refer to the contents also over the course of our discussion. Supreme Court in para 117 makes certain statements about what is this copyright. It says copyright is a negative right. 1. It is movable property. 3, it is a property right. 4, it's an intangible. 5, it's an intellectual property right. 6, it's an incorporeal right. It's a privilege. So Supreme Court, if you look into para 88 and para 117, these are the characteristics of copyright concern. Question therefore is, are we able to decipher the meaning very precisely by referring to these qualities of copyright? May not be able to understand that. You'll possibly get the feeling of this, but may not be able to get a very technical delineation of what is the difference between intangible, intellectual, incorporeal, and privilege. It's going to be very difficult for us. We'll only understand that these are the attributes given by the Supreme Court to a copyright. Two paragraphs, paragraph 88 and paragraph 117 are critical. But what's important for us to understand, therefore, is have this at the back of our mind. Then go to a transaction analysis to what happens really in relation to a software. There's a person who creates a program. He is the author of the program. He creates. That is the highest level of property for a copyright law. A person who creates a program, who is said to be the author, it is undoubted that he owns all the rights in relation to that program. This program may not be available for use in a computer automatically or immediately. So you need to modify this program, add certain attributes to it to make it functional. Therefore, this program then gets converted into a software, which is defined to mean a set of instructions to enable a computer to perform particular tasks. So therefore, a program gets converted into a software. Again, in relation to software also, though a program is modified to enable a software being functional or to make a computer function, these two are, again, in my opinion, close to each other, and they are to be regarded as forming the essence of the copyright ownership. Copyright, and particularly software, has a very easy peculiarity of multiplicating itself or replicating. Very easy to multiply, very easy to replicate. And therefore, you're able to create many copies of that software concern. It may not be that easy in relation to a patent invention model, because when you have to recreate that machine or a particular tangible item, the ability to create multiple copies of that may not be available. But that is a characteristics of a software where it is available, amenable to multiplication. As a result of it, therefore, we are able to have transactions seeing every day, seeing these transactions every day in relation to a copy of a software. Therefore, we look at a program, a software, and a copy of the software. This distinction becomes very critical for us because we're trying to understand in relation to a copy of a software, when you make a payment for a copy of a software, whether this payment made for a copy of a software is to be regarded as royalty. When I make a payment for transfer of the program, when I make a payment for transfer of the software itself, that means rights are moving away. Those rights can happen by an absolute sale, full transfer of property concerned. We don't have much of an issue. Possibly capital gains will address this unless I'm in the business of creating software and selling them, whereunder it may be business income, but that's a rare phenomenon. Largely possible to say that when I'm able to sell the title into the program or the software, I should be getting capital gains. So the title can happen absolutely. The title can happen partially. The partial transfer of title is called as assignment, dealt with by section 18 and 19 of the copyright law. That means a person can, when he has a number of rights that are given to him by virtue of section 14 of the Income Tax Act, so out of these rights, he may transfer all of these rights, or he may transfer some of the rights for a consideration, making the purchaser a owner along with, or even to the exclusion of the original owner itself. Therefore, I'm transferring certain rights in favor of a particular person. These are not all the rights concerned. Some of the rights available to me under section 14 of the Copyrights Act, I assign it in favor of somebody else. And section 18 subsection 2 says, when these rights are assigned in favor of an assignee, that assignee is to be regarded as the owner of that copyright. And therefore, assignee replaces the original owner as regards the type of rights are available to a person concerned by virtue of section 14 of the copyright law. Here also may not be much of a difficulty in terms of understanding what an assignment leads to. It gives rise largely to capital gains income. That's what the model commentary recommends, and the commentary tells us that it should be given to us as capital gains income. Below a sale, below an assignment is a license. Section 30 of the Copyrights Act deals with license. Now, a person has a lot of rights. The author has a lot of rights by virtue of section 14 of the copyright law. When he creates an interest in those rights, section 30 says he is said to have granted a license to the other person concerned. So very interesting now. This interest that is being created is distinct and different from an assignment that happens where the law itself creates and states that under 18.2, assignee shall be an owner. No such explicit statement is available under section 30 that a person in favor of whom an interest in the right is created, whether he becomes the owner or not. What is done is by section 2, subsection J of the copyright law, an exclusive licensee is defined to say that this exclusive licensee shall have all rights available to him under section 14 of the copyright law, even to the exclusion of the owner or the author of that program concerned. And therefore, to that extent, an exclusive license becomes closed. He possibly replaces the owner also. That is made clear by section 54 of the Copyright Act, which says that unless otherwise stated, unless we state otherwise, an exclusive licensee shall be regarded as an owner of the copyright itself. And therefore, 2J, or written section 54 of the Copyright Law, would tell us that an exclusive license shall be equal to an owner, unless the context otherwise requires. What happens is that in relation to an exclusive licensee, if there is an infringement that happens by a third party concerned, can an exclusive licensee bring about an action, or should we wait for the original owner or the author concerned to bring about an action for infringement? There may be some difficulty in understanding that concept concern, and therefore they're saying that we are making exclusive licensee the owner unless otherwise provided for us by the copyright law. Otherwise, an exclusive licensee is the owner. Now, a person who is not an exclusive licensee, who becomes an ordinary licensee, is he the owner concerned? That becomes the difficult portion, that becomes the whole gist or whole soul of the decision of the Supreme Court. What does license mean to us? That if I have given a license to do a particular act, then I am permitted to do an act. And if I were to do an act, I'll not be called as a person who infringes the rights of somebody else. It's like section 52 of the Indian Easements Act, which says that if you have a license granted to you, then if you enter somebody else's property, you will not be regarded as a trespasser concerned. You will be having a valid right to get into somebody else's property. So a license allows me to do a particular act, and which act will not constitute an infringement of the rights of an owner concerned. And therefore, the aspect of license becomes critical. We have to understand whether this license that is granted to a person concerned tantamounts to transfer of those rights under section 14 available with the author, and therefore whether the payment made therefore shall be regarded as royalty. This becomes the soul of the entire discussion, the crux of the entire discussion. Before we go to section 30, we also have to be therefore concerned with section 14 of the Copyright Act and section 16 of the Copyright Act. 14 has, as far as software is concerned, two limbs, limb A and limb B. Limb A has about 7 rights. Out of the 7 rights, the first 2 rights are very, very critical. The right to reproduce a software is a very critical right available to the owner concerned. And the right to issue copies, the second right we are concerned with is the right to issue copies, not being copies already in circulation. Therefore, 2 rights. The right to reproduce is an extremely significant right, and the right to issue copies. Now, these are copies which are being put into circulation for the first time. A copy already in circulation, there's no question of having a right to issue that again for the public itself. An explanation to section 14 says, when a copy of a software is first sold or is already been sold, then it's already in circulation. There's no question of having a right to issue the copy all over again. That means when you sell the copy subsequently concerned, you don't enjoy the right to issue. You don't enjoy the ability to put the copy into circulation. Putting into circulation means for the first time being made available to the public concerned. For the first time, the title of the property moves from an owner to somebody else, be it the distributor or be it the end user. The transfer of title can be by way of a sale, can be by way of a gift, or by way of any other transfer concern. And therefore, the movement from an owner of a title would tantamount to putting the copies in circulation. That is also explained by section 14 of the copyright and validated by section 14 of the copyright law. The other rights that are there is right to perform the work, right to make a film, right to make a translation, right to make an adaptation. These are 6 rights, and in relation to translation and adaptation, all the 6 rights is constituting the 7th right. That means you could, in relation to the translation and adaptation, reproduce, issue copies, perform the work in public, or make a film thereof. So in relation to this translation, there are certain other variations you can make, and that is also covered by limb 7 of the definition concern. There is 14b(2) that is very peculiar to software. This becomes the crux again of the entire discussion. It says that copyright shall include a right to sell or for offer for rentals, a right to sell a copy of the software, a right to give a commercial rental, a copy of the software shall tantamount to a right that the owner is said to have. Now, very interesting. 14a talks about copyright, that means the program per se. 14b(2) that we're looking at talks about a copy of the computer program. And in relation to a copy of the computer program, if I have the ability to sell or if I have the ability to offer for sale, then offer for rentals, it will be regarded as tantamounting to exercising the rights by an owner in the software concerned. And these rights are therefore vis-a-vis the copy of the software concerned. And we therefore have to understand the meaning of the right to sell under 14b(2). Section 16 of the Copyright Act says that there shall be no other copyright other than as have been prescribed under the statute. Therefore, you cannot imagine anything else to be constituting copyrights other than those that have been provided for under the statute. You have seen that section 30 tells you that because you've got a license, you're not supposed to have infringed. Section 52 protects that right to say that, yes, if you are allowed to do certain acts in accordance with the terms of the license, you will not be regarded as a person who has infringed the rights of the copyright owner. Therefore, 52, both limb 1AA and the limb 1A will be important for us in understanding as to what is meant by infringement. Now, having seen the background, we'll now come down to the real essence of the issue concerned as to whether the payment under a license is tantamounting to a royalty. What do you mean by a license? We're in section 30 of the income tax of the copyright law giving rise to a license. But when I buy a copy of a computer software, I also get an end user license agreement. Therefore, there's a EULA agreement. Now, what is this EULA agreement talking about? What is section 30 of the copyright law talking about? Is there any difference between these two concerns? And is there therefore a need for us to bifurcate or differentiate between these two types of licenses? When I acquire a copy of a computer software, let us say I'm buying a Microsoft Office and I'm making a payment concern, I have acquired a copy of the computer software. This is given to me, let us say, in a physical form. I have become the owner of that copy concern. Now, if I become an owner of a copy concerned, have I therefore paid consideration? Yes. Is there therefore an ownership right available to me as far as this physical copy is concerned? Yes. Now, am I therefore allowed to exercise certain rights in relation to that software? Section 52 of the Act would say a right to reproduce on your computer system for archival purposes or for use purposes will not tantamount to an infringement of the copyright. That means a right to reproduce is one of the rights given to us under the copyright law. But if I were to, in relation to a copy of a software, reproduce that software on my computer system only for the purpose of using that or for archival purposes, that will not tantamount to an infringement. That means the law itself tells me that when I buy a copy of a computer software program for a consideration and I use that on a computer system by copying it, it will not tantamount to any infringement. The protection is given to me by the statute itself. That means a EULA agreement doesn't do anything more, doesn't confer a protection to me, which is not available to me under the statute. It doesn't give me anything further. It's only a contractual arrangement between the person who is the owner of the copyright concern to say that you shall not disassemble, you shall not create a derivative, you shall not resell that. There are so many rights available there are so many rights available. As a purchaser of a copy of a computer software, I am saying very clearly that I shall use it only for the specified purposes. I'm agreeing that I shall not disassemble that. I should not create derivative program. I should not therefore do anything else in relation to that software. Those are therefore contractual rights, understandable by me, agreed by me through a EULA agreement. I have generally actually a protection given to me by section 52 of the copyright law. And therefore, even if in an extreme situation, the EULA agreement were not to be there, I will not be regarded as violating any of the copyrights concerned, because I paid a consideration for the physical copy, which has embedded in it a copy of the software program inside it. It's like, therefore, courts are comparing this to a buying of a book concern. When I buy a book, I'm allowed to use that book concern. And therefore, there is no violation where I'm allowed to use that book concern. To the extent that I'm also resell the book. So if I am therefore having a copy of a physical medium of a software program, and I therefore paid consideration, I become the owner of that physical medium. If I were to therefore make a statement that is like a book for me, I can therefore sell that book to somebody else. I'll not be violating the law. It's also like let us take a car today, which has a huge amount of software built into it for its functioning. I'm making a payment for a car. I'm not making a payment for a software, although software is dominant in making the car functional. Because the software is not sold to me independently. That software which is there in the car is not sold to me independently. It comes along with the car, and I'm primarily making a payment for a car. And therefore, if you were to make this analysis, when I make a payment for a copy in a physical form of a computer software, then I'm making a payment for a copyrighted article. I'm buying some sort of a goods, and I'm not therefore having any rights of section 14 of the owner coming into me. The small right that I have in relation to reproduction will not tantamount to exercising the rights of an owner. Therefore, this type of an end user payment does not give rise to any royalty payments. Other way to support this would be that there is no exclusivity as far as the end user is concerned. There is no parting of rights from the copyright owner of those rights available under section 14 of the copyright law in favor of the end user concerned. And therefore, the payment made by an end user of a software copy will not tantamount or should not tantamount to royalty. This is as far as a bare software is concerned. That's very easy to understand. If you are, by virtue of a payment concerned, becoming an exclusive licensee, generally you will not be a user concerned. Therefore, when you look at the transaction from an end user's point of view, the law becomes a little easy. Therefore, law is a little less complicated. End user acquires the copy. He uses the copy for the purpose of his commercial reason. He may use the copy for the purpose of his personal purposes. He has certain rights to reproduce, but those are not tantamount to exercising any rights of the owner concerned. In some larger organizations, they have a number of site licenses concerned. Therefore, they let us say buy 1,000 copies and they're allowed to reproduce that license concern. So these organizations, therefore, are allowed to multiply depending on the number of sites at which they would like to have this software deployed. Even this right of reproduction, right of replication is limited to making that software copy available for each particular computer concerned. And therefore, again, it'll be like 1,000 copies purchased. So 1,000 copies of a software being purchased by that enterprise concerned. And this right of reproduction is not like a right of reproduction available to the owner under section 14 of the copyright law. And therefore, here also, we will not have much of a difficulty. Therefore, what's important for us to understand is that in the case of an end user, the payment is making is largely a payment for a sale consideration of goods, not tantamounting to royalty. This is what Supreme Court has also categorically held, especially in relation to end user. The law becomes a little easy. The law gets a little complicated when we go into the aspect of a distributor. When I made a statement that Supreme Court has said that we would like to refer, in relation to an end user, we might refer to para 73 and para 72 of the Supreme Court decision. The Supreme Court said that there is a reference to the word granting of a license in limb 5 of the definition of royalty. Transfer of all or any rights in relation to a copyright, and within brackets, including granting of a license. Therefore, Supreme Court is asking a question to itself, what do you mean by this term granting of a license? Supreme Court in para 73 makes a statement that this granting of a license has to be understood in the background of the preceding words. transfer of all or any rights, including granting of a license. And therefore, Supreme Court said the granting of license is not to be understood separately. It has to be understood juxtaposed with the preceding words. That means there has to be a transfer of rights in favor of somebody else. Those transfer of rights are those that are spoken of in section 14 of the copyright law. Therefore, transfer of rights is very critical. When this transfer of rights becomes very critical, Supreme Court said, unless there is this transfer of rights, unless there is a parting, unless there is a movement from the owner in favor of the user of the copy of the computer program, it cannot give rise to a royalty payment. And Supreme Court said, this is the essence of the royalty transaction. Therefore, despite there being difference in the wordings of the treaty and the act, what does the treaty say? Use or right to use the copyright. What does the act say? Transfer of all or any rights, including granting of license in relation to a software program. The wordings are distinct, wordings are different. But Supreme Court said, whatever be the difference in wordings concerned, para 72, it says very categorically, despite the difference in wordings, the essence is that there has to be an exclusivity, one, and there has to be a parting of the rights. That means the person who is now having the software copy should replace the owner. If that were to be the situation, then you can say that there is some sort of a parting of section 14 rights giving rise to royalties. If that doesn't happen, there is no parting of rights. There is no populating the end user by these attributes of the owner concerned. Then it's tantamounting to a payment for purchase of goods, giving rise to business income. It cannot give rise to royalty income. One of the interesting arguments of the department was, look at the royalty definition. Limb 4A talks about use or right to use an industrial, commercial, or scientific equipment. Look at limb 3, use of a patent, invention, model, design, secret formula, process, trademark, or similar property. Especially relying on limb 4A, the department advocate said, the concept of letting is very critical. Concept of letting has become very critical. So leasing is critical, licensing is critical. So under 4A, you have leasing, you have letting, you have licensing, and this becomes royalty. If letting is the essence of limb 4A, where the words used are use or right to use, then letting should also be the philosophy of understanding the definition of copyright under the treaty, where it says use or right to use the copyright. It should also be the philosophy as far as limb 5 under the Income Tax Act is concerned, in talking about transfer of all or any rights, including granting of an interest. Transfer of all or any rights means lease creates an interest. That's what we understand in normal immovable property is concerned. And therefore, there is a transfer of interest, as a result of which, therefore, letting should give rise to royalty, and letting shall tantamount to a licensing of a software, and therefore, it will be equivalent to licensing of a software. And therefore, the consideration for licensing is equivalent to letting, therefore should be a royalty. Supreme Court negated this novel argument by saying, no, mere letting, mere licensing is not sufficient, because you're not dealing with an equipment per se, we're dealing with a copyright law. There is a particular outlining of the rights. Section 14 is very categorical. Section 16 is very categorical. Therefore, unless Section 14 and 16 are satisfied, you are not able to make a statement that the payments are for the copyrights itself. They may be for a physical medium or a goods concern. They are not for any of the rights as mentioned in Section 14, particularly in the light of an explicit law available to us as far as copyrights are concerned. Therefore, Supreme Court said that the aspect of letting will not be critical as far as copies of software are concerned. As far as, therefore, the end users are concerned, that's very easy. Now, as far as the distributor is concerned, that the law becomes a little difficult. The law becomes a little troublesome, particularly because of the differentiation and the multiplicity or multiplication of the rights that are available to a distributor. What does the distributor do? He buys a number of copies concerned. What does he do thereafter? He sells those copies. Now, when he sells the copies, has he acquired some sort of a rights of a copyright owner? When he has, therefore, let us say a very micro level example, that a distributor buys an Oracle software program, 1,000 copies of it, and he therefore sells them in the market concern. Question therefore for us is, does the distributor have a right to sell? Does he have a right to issue copies? Does he have a right to issue copies? And therefore, is he making a payment for acquiring this right to sell? Is he making a payment for acquiring the right to issue copies to the public? Therefore, what is the right that a distributor is enjoying by having a right in relation to this 1,000 copies concern? Is it something that is now specifically conferred upon the distributor by the owner concerned, or is this a right that is normally and naturally available to a distributor? Take the for example of a owner of a copyright who then allows a distributor to avail of 1,000 copies, and that distributor sells these licenses in physical form to the end user concerned. So we have to therefore understand end user to distributor, what happens? Distributor to the owner, what happens? End user to the distributor, we have already seen. We are now reasonably comfortable to say that unless the rights move from the owner to the distributor and therefore they move down to the end user concerned, it cannot partake of the nature of royalty concern. Therefore, that portion is easy for us. From the distributor to the owner concerned, would the payment partake of the nature of royalty? Becomes the core of our discussion concern. Now, is the right available to a distributor as it is? Because any distributor is buying and selling goods, that right is available to him. It's not a right specifically conferred or additionally conferred to him by the copyright law. Therefore, when he buys 1,000 copies, he sells those 1,000 copies. What is he making a payment to the owner concerned? Is he making a payment for acquiring copies to be resold, or is he making a payment to the owner concerned for having his right transferred to him? What is the right transferred to him? I'll repeat again, two things: right to reproduce, right to issue copy. These are two critical rights available under section 14A, limb 1 and limb 2. Right to reproduce copies, right to therefore issue copies to a public in circulation. We will take the second limb easier first, because right to issue copies would exclude those copies that are already in circulation. That's very easy therefore. Therefore, when the owner of the copyright creates the 1,000 copies and sells the 1,000 copies to the distributor, he has sold them to the distributor concerned. When a sale happens, therefore, possible to argue that these copies are already in circulation, and therefore the payment made by the distributor to the owner concerned will not be regarded as royalty. Let us change the example slightly. Instead of 1,000 copies being physically purchased, the distributor is allowed to reproduce 1,000 copies and sell it to the customer concerned. Therefore, does he have the right to reproduce? Now, he has the right to reproduce. The answer could be yes. How many copies? 1,000 copies. Does he have therefore the unlimited right to produce as many copies as he wants? The answer is no. He doesn't have that right concerned. Therefore, the right that is available to an owner is uninhibited right. It has absolute right, no limitations attached to it. 1,000 copies being produced is only to control the number of copies that are available in the market concerned. That right of reproduction, therefore, would not tantamount to the rights of the owner moving in favor of the distributor concerned. That's an essence of understanding that what the distributor is now getting is a payment made for transfer of title in relation to those 1,000 copies concerned. He doesn't acquire the rights that are enshrined in section 14A1 of the 1 or 2 of the copyright law, and therefore the payment made by him cannot tantamount to royalties itself. This also is bolstered by the fact of a principle of exhaustion or principle of first sale. This is a very interesting concept that we should encourage trade. We should therefore encourage the free movement concern. We are also looking at the protection to the copyright owner. He should get his commercial benefit for all the efforts he has put in to create the copyright. He has to get the benefit. Now, when he sells that to the distributor concerned, he has got his commercial benefits. And therefore, the law would say that when a copy is sold for the first time, it then stops the copyright owner's ability to further exploit it. This is the principle of exhaustion. The copyright owner are exhausted, they are transferred to a distributor. There's a difference between transferring the ownership rights to a distributor and having the copyright exhausted in the hands of the owner itself. When he therefore sells this 1,000 copies to the distributor concerned, what happens is there is a principle of first sale, and this principle of first sale would exhaust the right of the copyright owner to get any further royalties on subsequent transactions concerned. Therefore, when this person is selling, the distributor is selling to end user or is selling to a shopkeeper, then goes to the end user, there will be 2 or 3 downward sales from the distributor concerned. Now, Because of the principle of first sale, it exhausts the copyright owner's right in relation to that copy concerned. Therefore, the copyright owner will have no right in relation to the further sales happening. He's not expected to get a royalty. Therefore, it stops. All the payments concerned, therefore, are not in relation to movement of copyright. That right is actually exhausted there. Therefore, the payments under the subsequent sales, even the move up, cannot be regarded as payment towards royalty. And therefore, the principle of first sale or a principle of exhaustion, therefore, promotes further sale down, Therefore, they say that when you have a license or when you have an authority to reproduce and or to issue copies to the public, this has to be right along with the right of the principle of exhaustion, the principle of first sale, which will then exhaust the right of the owner concerned. Therefore, he has got royalty once, he has got the commercial benefit in relation to this copy is concerned. He is not entitled to any further remuneration as far as the downward sales are concerned, as far as that copy is concerned. Now, this is as far as 14A 1 and 2 is concerned. The problem is arising because of 14B2. I repeat again, 14A limb 1 and limb 2 says reproduce the work, and it says the right to issue copies not being copies already in circulation. Contrast 14A2, or it is 14B2 of the Copyright Act, which says a right to sell or offer for rental a copy of the computer program will amount to a ownership right, will amount therefore to a copyright. Therefore, payments for that should be regarded as royalty. Therefore, what the distributor is having now, he's having a right to sell. Therefore, he's now giving it to the owners, to the end users concerned. So he's therefore having a right to sell. He's therefore having the right to give it on list to somebody else. And therefore, the payment received by the distributor under 14B2 are they to be regarded as royalties concerned. What do you understand, therefore, by the right to sell or offer for sale or offer for commercial rental a copy of the computer program? So this is a right that is specifically mentioned only for the purpose of computer program. An additional available item is in relation to a movie copyrighted film. So only in these two areas we have this aspect of right of sale or offer for rentals a copy of the computer program to be regarded as royalties. There was a portion that was there which was deleted in 2000. So a right to sell or offer for sale, regardless of whether any copy has already been put into circulation otherwise. There was an earlier law which got deleted in 2000. Regardless of whether a copy is already in circulation, that portion has now been deleted. And the Supreme Court was asked to examine the impact of the deletion of these words concerned. Supreme Court said, earlier, when the words were there in the statute, regardless of, that means whether or not the copy was already sold down the line, they said the right of the copyright owner continued to exist. That means Supreme Court said 14B was not accepting the principle of exhaustion, was not accepting the principle of first sale. Whether or not the copy was already sold, any further sale gave rise to the owner concerned, therefore it ought to have been regarded as royalties. Supreme Court is now saying, when you remove this word, regardless of whether the copy is already available or already given in circulation, they remove these words. That means the owner's rights are limited because he doesn't now get the right of royalty in relation to further sales. He doesn't get the commercial bargain in relation to sales thereafter. And therefore, Supreme Court said the word, the phrase regardless having been eliminated, it now curtails the software owner's right. Therefore, on subsequent sales, he does not get, or he doesn't have the right to get the royalty. This appears to be slightly contradictory to the explanation given by the government when it had similar words in relation to a movie being deleted. In relation to a movie also, when you had a copy of the movie being sold, the words were there, regardless of whether the copy of the movie is already in circulation. They were also removed, and they were removed in 2010. The notes and clauses say that we're removing this not to restrict the copyright owner's rights, but to expand the copyright owner's rights. Now, this was not brought, these notes and clauses were not brought to the attention of the Supreme Court in this decision concern. The Supreme Court, in its own understanding, relying on some High Court decisions and AR ruling, especially Dassault's case, said that the regardless means that we are now narrowing down the owner's right, and therefore, once a copy is put in circulation, it will not give rise to a right to him. This is one part of the story. Supreme Court also said, what do we mean by right to sell? What do you mean by a right to sell? What do you mean by right to offer for commercial renters this property is concerned? We have to give a meaning to that. Supreme Court said, what do you mean by right to sell? A right to sell is available to a person as a distributor. There's a commercial right available. This is a special right we're dealing with under the copyrights law. Therefore, it has to be given a special meaning. 14b(2) has to be given a special meaning. The right to sell has to be accompanied by a right to reproduce. This has to be accompanied by a right to reproduce. That means 14b(2), when it talks about a right to sell, Supreme Court says in para 128, says that we are interdicting, we are therefore prohibiting a right to reproduce and sell. A right to sell is available. What you're now trying to say is that the person who has now got a right, a distributor, he doesn't have a right to reproduce and sell. He only has the right to sell. When he has the right to reproduce and sell, only then we will look at a copyright ownership's right going right to the distributor concern. I'll repeat again. This is very extremely critical. The understanding of the Supreme Court is that for us to look at 14 rights of the Copyright Act having moved to somebody else, demonstrate three things. One is the exclusivity. What do you mean by exclusivity? It means exclusivity to do, or the authorization of somebody else to do the act concern, to do or authorize somebody else to do. Now, when a distributor is acquiring 1,000 copies, okay, can he authorize somebody else to do, or somebody else to, can he do it himself, or can he authorize somebody else? What can he authorize? He can only authorize to the extent of 1,000 copies. That means he is not exclusive. The owner is exclusive. His rights are very, very limited. The parting is not happening. Section 14 rights therefore are not happened because of the exclusivity concept not being there as far as this distributor is concerned. When the exclusivity concept is not there as far as the distributor is concerned, it then amounts to a situation where he doesn't have the ownership rights. The right of reproduction therefore is critical before you understand the right to sell under 14b(2) of the copyright law. And therefore, Supreme Court is understanding right to sell under 14b(2) as right to reproduce and sell, or right to reproduce and offer for rentals a copy of the computer program. Without this right to reproduce, it cannot be a situation where you're able to say that the copyright ownership rights have gone on to the person concerned. And this is extremely important, therefore, in the Supreme Court's verdict, that the exclusivity, the parting, that means the person in whose favor, be it the distributor, he should come and stand on an equal footing along with the owner. In some respects, he should be able to oust the owner, or in some respects, he should be able to exercise particular rights without recourse to the owner of the copyright concern. Without recourse, that way to happen. If he is ousting the copyright owner's position, only then we can say that Section 14 rights have moved to him. And then only the payment made by him to the copyright owner can be regarded as royalties. And therefore, this becomes very interesting as far as Supreme Court is concerned, that reading of 14b(2) can be a bone of contention in the way Supreme Court is understood to say that 14b(2) talks about the right of reproduction and sale. And if a distributor is not exhibiting the right of reproduction and sale, and right of reproduction has to be exclusive, that means it should be equivalent to an owner, unlimited right, should be therefore something that cannot be curbed. That will be the right available to a distributor. Then the payment made by him to the owner of the copyright can be regarded as royalty. And therefore, Supreme Court has understood the word right to use in a slightly different context, and using this, it has given the benefit of the judgment in favor of the assessors concerned. And also it's important to note that even these distributors that were before the Supreme Court had a license agreement entered into. Supreme Court extracted portions of those license agreements and then said, Supreme Court said, what I observed from the license agreement, in IBM license agreement or Autodesk license agreement, Supreme Court said, what I'm observing from the license agreement is that the distributors expressly prohibited from replicating, from reproducing, from selling, from derivating, from decompiling. So he has been expressly prohibited, and therefore this also was helping the Supreme Court in coming to a conclusion that no rights of the copyright owner have passed on to the distributor concerned. Therefore, Supreme Court came to a conclusion that in these circumstances, the payment made by the distributor to the copyright owner did not or does not tantamount to royalty. What's important, therefore, is that we have to appreciate that Supreme Court came to the conclusion because of the contracts in place. And Section 30 is a contractual right. Section 30, when it grants a license to a person concerned, is a contractual right. We have to be very careful about these contractual rights. To what extent the owner has parted with rights in favor of the distributor concerned becomes very, very critical. Are their rights very bare minimal rights? Then the license, the person in favor of whom the rights are given, he is making a payment of sale consideration. When the rights are upgraded to an ownership rights equivalent to the owner, what he enjoys under 14A and 14B of the copyright law, only at that point of time can it be held that the payments made are tantamounting to royalties. And therefore, Supreme Court, when it examined 14B2, made a very categorical statement that the rights to reproduce and sell, these two aspects have to be cumulatively satisfied before you can say that the transaction falls under 14B2. It's also important for us to understand that these distribution rights are not necessarily uniform across the world. And the Supreme Court had an occasion to refer to a US decision where, for example, a Thailand person was able to import copies of study material available cheaply at Thailand. He imported those copies into US and sold them. The question therefore was, is this act by the student concerned of importing copies from Thailand tantamounting to a violation of the copyrights, because the rights to get that and sell that in the market, is he infringing? He's not taking a permission from me. Is he infringing therefore? Supreme Court in US said that for us, the principle of exhaustion is universal. That means wherever a copy is produced and sold, that means it is sold, it's put into circulation. Therefore, anywhere in the world, the copy has been produced and sold, it exhausts the copyright owner's further compensation concern. And therefore, if it was printed in Thailand and sold in Thailand, this was imported by a student in USA, the principle of exhaustion already applies. The copies printed there would exhaust the copyright owner's right, and therefore the import into US and the sale thereof was not tantamount to the infringement to the valid act. The copyright owner was not entitled to any compensation. The payment were not royalty. As contrasted with that, the rights of the principles of exhaustion in India are national. They are not international. Therefore, in India, I see for the first time demonstrate I have a right to sell. The copies produced outside would not necessarily mean that the copy is available for circulation in India. Demonstrate for the first time that they were brought into India. The transfer of title happened in India, and they are now issued to the public for the first time. Therefore, as far as India is concerned, the principle of exhaustion is a national right. Other countries like US have an international principle of exhaustion, and therefore those will be understood differently in different countries of the world. What's important, therefore, is again small way of reiterating the principle concerned, that in arriving at this conclusion, Supreme Court went into Section 2M of the copyright law and found out what we mean by an infringing copy. Infringing copy is that copy which has been reproduced without the rights or without the license from the owner. Section 52, therefore, Supreme Court read Section 2M and 52 of the copyright law and said that the right of reproduction is the heart and soul of the copyright law. The right of reproduction and the exploitation of the product out of this reproduction is the heart and soul of the copyright law. And therefore, there is no right of reproduction. It can't amount to an infringement. Reproduction is a prerequisite for an infringement. Therefore, Supreme Court read 14B2 as a right to reproduce and sell thereafter. Without a reproduction right, in the words of Supreme Court, there could not have been an infringement. As a result of it, therefore, Supreme Court said that the right of reproduction and the right of sale thereafter shall be prerequisites for the purpose of understanding whether royalty were to be existing or not in a particular transaction. So when you understand this, therefore, as far as the current case is concerned, none of the distributors and the end users had the rights of Section 14 of the copyright law moving. Though the answer to this was very easy. But what's important for us to understand, therefore, is the Supreme Court went into a very broader conspectus and explained to us as to how we should understand the law. Therefore, it's very important for us to get out the principles of the Supreme Court decision, which are going beyond the facts of the case concerned. They're giving us the outline of the law concerned. We therefore have to understand 14A, limb 1 and limb 2, and 14B2 as the core essence of copyright law, and it has to be exclusive. There has to be a parting of the rights concerned, and to that extent, therefore, the person in whose favor these rights are parted with should stand on equal footing with the owner concerned. Only then it will tantamount to a royalty, because there is a movement of the rights, there's a parting of the rights concerned. Otherwise, it will not tantamount to a royalty payment at all. Para 117 of the Supreme Court decision is now therefore recapitulating 6 important principles, and therefore what we've discussed today till now are captured by the Supreme Court in para 117 after taking into account the entire discussion on copyright law, on the Income Tax Act, on the decisions under the Income Tax Act, and therefore the principles laid on are under 117 of the Supreme Court decision. 6 important principles are laid out. I thought we should stop here in relation to understanding the interplay between copyright law and the Income Tax Act and move to some other important implications of the Supreme Court decisions in some other facet the Supreme Court has touched upon. Because they are important, we have to understand, I made a statement that there could be some other issues, some other transactions, some other situations which Supreme Court has not expressly dealt with, and we have to understand the ramifications of those situations concerned. And one concerns explanation 4 to 916. Explanation 4 was added by Finance Act 2012 with a prospective effect from 1/6/1976. What does it say? It tries to expand. It tries to expand the definition of royalty by saying what? That we have limb 5 of 916, which talks about, in relation to copyrights, transfer of all or any rights, including the granting of a license. The Supreme Court, the legislature was concerned with what happens when there is a transaction of a use or right to use a copy of a computer program. Moving away, because these are the use or right to use is not something that is available under the Income Tax Act in relation to copyright. We have already seen is available to us under the treaty, use or right to use. Rightly or wrongly, explanation 4 was trying to make a statement that royalty today in relation to computer software shall include the right for use or right to use a computer software. Therefore, Supreme Court said whether this is a correct understanding, whether explanation 4 expands the understanding of explanation 2, which defines royalty. In the course of dealing with explanation 4, the counsel for the SSC, Pardiola, said, look at the terms used in explanation 4. They refer to right, property, or information. That's the starting of explanation 4. We don't find right, property, and information anywhere in explanation 2. These are words available under 916B or 916C, right, property and information, royalty in relation to payment for a right, property, or information. Therefore, those are the words used only in 916B. And therefore, we have to understand explanation 4 as referring to 916B. It in no manner, therefore, has anything to do with explanation 2. Supreme Court did not agree with the Assessors Council on this matter. Supreme Court said no. Look at 916 limb 5, explanation 2 limb 5. It says transfer of all or any rights. Therefore, rights is already there. So when you look at explanation 4, when it says right, property, information, you cannot say, therefore, that is entirely distinct or subject matter. The word rights are used in limb 5. Therefore, we are unable to accept that explanation 4 deals only with 916. It does not deal with explanation 2. Supreme Court therefore says we are unable to accept the council's argument on this aspect. Having said that, Supreme Court said, therefore, explanation 4 expands the definition of royalty. This is the observation made by the Supreme Court. Now, in what manner it expands, Supreme Court stopped short of making a statement. It says it expands. How does it expand? In what manner it expands now? Because we say that now, if you look at explanation 4, it says right for use or right to use a computer software shall tantamount to royalty. Therefore, now if I were to use a copy of a computer program, am I now using the computer program? I'm having the right to use the computer program, and therefore, will it tantamount to royalty? Supreme Court said, essence, what you are meaning it, use or right to use is something available to us under the treaty. Supreme Court said, the words use or right to use under the treaty would mandate, would presuppose a movement of or the parting of the exclusivity or the rights from the owner in favor of somebody else. Unless that happens, you cannot make a statement that there is a use or right to use. And therefore, Supreme Court did make a statement. We have already seen that the licensing that is spoken of in Limb 5 and the use or right to use in the treaty are not conveying anything distinct or separate or different. They are essentially referring to the same type of rights available. Therefore, it has to be some sort of a parting movement of right from the copyright owner in favor of the user concerned. And until that happens, it cannot tantamount to a royalty. And therefore, the words use or right to use that are available now under explanation 4. If you were to understand this in the context of the Supreme Court's understanding what use or right to use means, it means that there has to be a parting off. Until that parting happens, explanation 4 will not be satisfied, will not be attracted. It does not tantamount to a mere use of a copy of a computer program. It should be a use which is preceded by the movement of the rights under Section 14 of the Copyright Act from that person to the person who is now making a payment concern. And therefore, when you talk about explanation 4, not going by a specific explanation or a specific verdict by the Supreme Court, but just opposing the Supreme Court's analysis of use or right to use, and we were to transpose that analysis to explanation 4, we can draw a statement or an inference that explanation 4, therefore, will still fall short. Now, this is important to understand because Supreme Court is making a statement. Look at what explanation 4 is doing. It is adding something. What is it adding? It is adding to the definition of royalty. What is it adding? It is adding from 1976 certain items in relation to computer software. Supreme Court said, how can this be possible? The definition of computer program was for the first time introduced into the Income Tax Act in 1991 only. It was introduced for the first time in 1991. Therefore, how can you have an understanding of a computer program from 1976? Not possible. Then they said the copyright law was amended in 1994 to make a statement that literary program shall now include a computer program. Literary work shall include a computer software or computer program. This came when 1994. How can you therefore have an understanding from 1976? Not agreeable. Then what it did was it also said into the explanation 6, went into process. It said when of this process, the Cable and TV Rights Amendment Act regulations came in 1995. How are you trying to use the word process with a retrospective understanding from 1976? We are not agreeable to this. Therefore, when you look at explanation 4, we are not willing to apply explanation 4 to all the decisions itself. We are not willing to apply the explanation 4 to all the decisions, and therefore to us, explanation 4 is not applicable on the statute books. Now, interestingly, Supreme Court said the amendments came in 1991 or 1994 or 1995. Supreme Court said you could not have, therefore, had an amendment to the law or understanding from 1976. Fine, that portion is well taken. Now, what about from 1991, 1994, and 1995, when the amendment were brought into the statute book? Can you therefore at least have the retrospectivity from 1991, from 1994, and 1995? Now, interestingly, the cases before Supreme Court, for example, the EAC, the lead case, is for assessment year 2002-3 and 2003-4. They were post all the amendments made under 1991, 1994, 1995 regulations. When Supreme Court said, I'm not going to apply, it did not say that I'm going to apply from 1991 onward. It says, no, I'm going to give a decision in favor of the SSC, disregarding explanation 4. That means for them, explanation 4 was not applicable even for assessment at 2, 3, and 3, 4. That means explanation is applicable only from 12, 13 onward. It cannot be applicable for any earlier year. Is there a way of understanding the explanation 4? Now, assuming for a moment explanation 4 applies from 2012 onwards, we then go back to Supreme Court decision and understand that the transfer of all or any rights or the right for use or right to use a computer software should be accompanied with the exclusivity and parting of rights. Mere explanation 4 by itself doesn't create any additional expansion of scope of royalty itself. And therefore, if you were to understand, therefore, explanation 2 has to be read with explanation 4 has to be read with explanation 2. Unless there is a parting of right, unless there is that exclusivity, it cannot be regarded as royalty itself. Now, explanation 4 and this understanding of Supreme Court could give rise to very interesting consequences, because we are aware of explanation 2 below section 9. there is an explanation below 9 subsection 2. We had the Ishikawa-Wajima's decision, 288-8R-408, when they discussed about the services rendered outside, performed outside, utilized outside, and Supreme Court made certain observations concerned. To get out the Supreme Court decision, an explanation was added below 9 subsection 2. And the explanation was added with retrospective effect from 1976. Now, Supreme Court said, no. I can't apply at least retrospectively for treaties obligations concerned. And therefore, at least as far as all litigations concerned, not just under 916, even under explanation below 9 subsection 2, this decision will help us. 1. 2, very interestingly, Vodafone's case, they said leviable, tax is leviable. When the Supreme Court won the battle, they went behind Vodafone to say, hey, you ought to have deducted tax at source. And therefore, they started the battle all over again. What will happen now? Vodafone has taken advantage of the Supreme Court decision now to say, look here, Supreme Court has said this is only prospective. That means my battle, as the government is concerned in Vodafone's case, again has to go in favor of Vodafone, because if that were to be the interpretation concerned, Supreme Court not applying this law for any year prior to 2012 would mean Vodafone also should be allowed the benefit of this decision. That could be very interesting. Other could be that we are having under so many sections of the law itself, so many aspects, and therefore the retrospectivity also is an important issue for us. When looking at the law itself, and the Supreme Court said no retrospectivity because of the impossibility of performance. One of the reasons the Supreme Court said was, how do you expect the director concerned to look at the future law? How does he therefore have a premonition of the law that is going to come in the future? How does he therefore comply with the treaty's obligation? And therefore, the aspect of impossibility of performance also became a criteria for the Supreme Court to say that this shall be a case where I'm not going to have the treaty's obligations imposed on the players concerned. This aspect of retrospectivity can come or become handy to us in a fighting battles in different contexts. For example, under 45(5)(a), it says that a completion certificate is essential for you to have the benefit of 45(5)(a) being limited to a particular year. 80IB 10, we had a completion certificate to be given to us in relation to the housing projects concerned. We have 80IBA now also applicable to us. Therefore, in relation to those completion certificates could be critical for us. We also have under section 35(2)(ab) for battles on now. I've made my application to the authorities concerned. So whatever was there from my side, I have done that. There has been a problem from the point of view of the department side or the government side to give it that recognition. Supreme Court, when it dealt with the retrospectivity, went into a constitutional battle in relation to an election petition also. He said, I've done everything from my side and I'm awaiting the government's clearance. That's not under my control, and therefore there's an impossibility of me making the government to work on this. Supreme Court read to this Supreme Court this decision of the constitutional law and applied it for the purpose of the Income Tax Act also. And therefore, in situations where we have this aspect of recognition being delayed from the government's point of view, an impossibility of performance can be put forth, and we can make a claim in the appellate stage that the recognition is yet to come. But because there is something that is not in my hands concerned, applying this principle given by the Supreme Court, possible to say that the aspect of impossibility of performance in the way Supreme Court has read this out could be the basis for us to make a claim before the authority is concerned in all these aspects concerned. Explanation 4 by itself, therefore, is a case of a faulty drafting. Explanation 4 is saying right property or information. That right property information is not just unique to limb 5. Supreme Court has read that as applicable to all limbs of 9.1. So if you look into 9.1, therefore we have some sort of a understanding of what 9.1 explanation 2 talks about. Explanation 2 talks about first limb of intellectual property is called as patent, invention, model, design, secret formula, process, trademark, or similar property. For these type of intangibles, called as set 1 intangibles, there are 3 limbs available. Limb 1, limb 2, and limb 3. Limb 4 and 4 are not relevant for the time being. Limb 5 deals with copyright. That's the second set of intangibles. Now, interesting, when you compare the second set of intangibles, limb 5, it is only equivalent to limb 1 of the first set of intangibles. So transfer of all or any rights in relation to patent invention is the same right available under limb 5 in relation to copyright. 2 other limbs in relation to the patent, that means the conveying of information relating to the working or the use of patent, imparting of information, that right is not linked to a copyright. Use of patent, invention, model, design, secret formula is not linked to limb 5. Okay. So one thing is important for us when you understand this use of patent also, which is there. We can then use the Supreme Court decision to understand the use to say there has to be a parting of right. That helps us in understanding that limb 3 of the patent law. And that could be one of the implications of the spillover of Supreme Court decision to understand the limb 3 of the first set of copyrights. Now, we'll talk about these 3 types of limbs in first set and the aspect of limb 5 in relation to copyright. And you make a statement that right, property, and information cover all limbs of explanation 5. That means when I make a statement that I'm having a patent, and that patent is now equivalent to a copyrighted article software. Now, look at limb explanation for what it says. Right, property, information shall include the use or right to use a computer software. Now, when I have a patent and I have a use or right to use a patent, now, will a software be a patent now? Because the law Supreme Court is saying right, property, information refers to all the limbs concerned. There's no question of bifurcating or limiting this. The arguments of the council of the SSC were given up. Therefore, it says all 5 limbs, right, property, and information is not applicable. That way to happen now. Would software come into limb 1, 2, or 3? That is the possible effect of a Supreme Court decision, not reading explanation 4 along with limb 5, but reading it as applicable to all the limbs concerned. And interestingly, explanation 4 does not refer to the word royalty at all. It does not say royalty shall include so and so. Explanation 4 does not have the term royalty being used there at all. Therefore, possibly on this count also, the impact of explanation 4, should it be limited to limb 5 or should it go to all limbs of explanation, is giving rise to some unnecessary complications, which is better avoided. But Supreme Court went on to observe that this is the way we are reading it. And explanation limb 4 expands explanation 2. In what way it expands is stop short. How it expands is stop short. How right and property information, which are the limbs of explanation 2 that will apply. Supreme Court doesn't say anything on this matter. And therefore, to that extent, we may have some difficulty in understanding and applying Supreme Court to other limbs of explanation 2. We also have to therefore juxtapose this understanding of explanation 2, 4, vis-a-vis section 194J and 40A1 or 40A1A of the Income Tax Act. What is the understanding of 194J? 194J has 2 important ramifications. It says that 194J, along with the notification of 212, said that if the person who is making a payment to a non-resident is deducting tax at source under 195, then a subsequent sale by him will not be liable for TDS. Therefore, they said second sale will not be liable for TDS if the first sale had been liable for TDS under 195. Now, what happens is under the current law, first sale will not be liable for TDS because of Supreme Court decision. Now, second sale that will happen will therefore be liable in accordance with the notification of 2012, or are you going to say, no, whether or not the first sale was liable, because first sale was intrinsically not liable for the reason that this does not amount to royalty at all. The question therefore of saying that second limb is a continuation of first limb. When you make a statement, first limb is not liable, it should automatically mean second limb is liable. May not be an appropriate way of understanding 194J. To understand 194J in a sense to say whether the payment is royalty, and you understand whether it is royalty in the light of the way Supreme Court has expounded the definition. Therefore, unless it is royalty, the question of deducting tax doesn't arise, 195 will not be applicable. Then therefore, you don't have to look at the second limb to say there will be automatic tax deduction at source. Second limb also will be not tantamount to royalty. 194J should not be attracted. Therefore, there should not be a withholding tax in relation to second limb of the transaction concern. One. Other also understanding would be that 194J and 40A talks about one royalty as defined to us in explanation 2. Now, explanation 3, 4, 5, 6 are not referred to there. Explanation 2 is the stoppage point. Therefore, when you read royalty, understand royalty, possibly since there is a conscious limitation of the word royalty only to explanation 2, we can't use explanation 4 for the purpose of understanding royalty under 194J or under 40A or 40A1. And therefore, that could be one more implications of understanding the Supreme Court decision as far as 194J is concerned. We then go into the aspect of certain smaller topics now in respect of what happens in respect of. But before we go to the aspect of in respect of, we have to understand a Supreme Court principle as far as understanding the law is concerned. And this becomes another interesting topic for debate and discussion. What does the Supreme Court do? Supreme Court says I'm understanding royalty. Where am I understanding royalty? I'm understanding royalty under the Act and under the treaty. So what happens under the treaty? Treaty means royalty is defined under the treaty. And therefore, the definition of royalty as given to us under the treaty shall prevail. That's the way Supreme Court went about. When you have the royalty understanding of the treaty, fine, that is also in accordance with what Article 2 of the commentary would say. If a treaty defines the term, then go by the treaty definition. Don't have to go to the domestic law definition. Therefore, when treaty defines the term royalty, possibly don't have to go into the definition of royalty as given under 916. But the definition of royalty under the treaty refers to many terms: copyright, patent, invention, model, design, secret formula, and process. How do we understand these terms that are components or constituents of a definition that is defined under the treaty? Now, you don't find a definition of a copyright or a patent or an invention or a model or a design or a secret formula under the treaty. So these are terms which are constituents of a larger definition. When those terms are not defined, what should you do? Should you go automatically to the domestic law definition because we have copyright as defined to us under the copyright law? What should you do? How do you understand a definition of a term which is a constituent of a larger definition under the treaty concern? Now, if you go into Article 3, Subarticle 2 of the Model Convention, it says that where a term is used in a treaty but not defined, then unless the context otherwise requires. Therefore, if you want to go to a different definition, let us show the context otherwise requires. Or the latest definition says, unless the competent authorities of the country agree to a particular understanding of that term. So two things are there. The competent authorities of both the countries understand that particular term in a particular manner, that shall prevail. Otherwise, the context of the treaty shall prevail. And thus, the context of the treaty shall prevail. Therefore, if you are able to say the context of treaty is not providing for understanding in a common sense way, not providing for a situation where I can look at the competent authorities treaty concern, then they say, go to the domestic law. So I can go to the domestic law, only the context of the treaty permits me to or allows me to go to the treaty, to the income tax law definition or the local law definition. So local law definition could be a definition under the Income Tax Act, could also be a definition under some other enactment. Let us say, what is a sale? What are goods? Could be defined under the Income Tax Act. What is transfer? Could be defined under the Income Tax Act. Could be defined under the Transfer of Property Act. Could be defined in some other regulations concerned. But the same term, which is not defined in the treaty, is defined in multiple domestic laws concerned. What should you do? Article 3, Subarticle 2 says, if multiple definitions are there under multiple legislations concerned, go to the tax law definition and apply that definition concerned. This is as far as 3 Article 2 is concerned. Now, 3 Article 2 or Subarticle 2 also saying that what is the context? Context has to be the understanding of the parties when they entered into this treaty negotiation and agreement. That's the context. Therefore, they went into a treaty negotiation. They possibly were aware of the domestic law requirements of both the countries concerned. Having understood the domestic law requirements of both the countries, they negotiated a treaty at a particular point of time. Therefore, let us say a treaty was entered into in 1996 or 1995. Now, at that point of time, these negotiators should be presumed to have been aware of the domestic law situations concerned, and therefore, the understanding of a particular term should be in accordance with the law prevalent at that particular point of time. Let us say subsequently, one of the countries were to change the domestic law definition concerned. Let us say, therefore, in the case of a copyright we're dealing with, there have been changes both in the Income Tax Act and there have been changes in the copyright law. What are the changes in the Income Tax Act now? For example, 916(2) Lim 5 says, earlier they said a distribution of a movie will not be regarded as royalty, it will be regarded as business income. Now they said, no, a movie also will give rise to a royalty income only. This has happened very recently. This is not there when the treaty negotiator had entered into the agreement concern. We also have an amendment to the copyright law to say, regardless of whether or not these copies have been in circulation, is an amendment made in the domestic law. We don't have a similar enactment in the foreign law. We don't have a similar amendment in the foreign law concern. Now, when you make a change to the domestic law, are you now trying to give a different understanding than what the treaty negotiators had? And therefore, by virtue of a change in the domestic law, can you override the treaty in an indirect manner? Can this be called as a subtle treaty override by changing the domestic law concern? Therefore, 3.2 says, no, this will not done, this will not be permitted, or this should not to be permitted. We should therefore look at the understanding of these people concerned at the time the treaty was entered into, and therefore they're looking at the static approach to a treaty interpretation. Therefore, they said static approach is important. Look at what section 90 is telling us. 90 subsection 3 is telling us. It says where a treaty term is used but not defined in the treaty or in the act, not defined in the treaty or in the act. Now, what should you do? We should go into by the definition given by the government in a notification. Okay. One. Look at explanation 3. It says when this government by notification defines the term, then this definition will have effect from the day the treaty was entered into. So government has a notification today defining a particular term. This explanation 3, read with 90 subsection 3 would say, this government understanding through a notification shall be held as applicable from the date the treaty was entered into. This is contrary to the spirit of 3.2. Now, Supreme Court in para 168 says that the OECD has persuasive value. The model commentary has persuasive value. Therefore, when we possibly, this is not something that the Supreme Court was called upon to, but when we therefore have a clash between this type of 90 subsection 3, read explanation 3, and article 3 subarticle 2 of the model convention, a clash happens, trying to override the law by a domestic law amendment, then possibly by virtue of the verdict of the Supreme Court now, which says that no, model commentary shall have persuasive value. We are tuned to accept the way in which the model commentary has gone about this, then possibly the ambulatory approach, as there in explanation 3 to 90, should not be given the benefit. Explanation 4 also is there critical to say that if a term is used in a treaty but not defined, it should have the unless the context otherwise requires or the act or treaty otherwise provides. That's an interesting issue. Unless the context otherwise provides or the act or the treaty otherwise requires, it will have the meaning as given under the domestic law. To that extent, therefore, we may have some sort of parity as far as explanation 4 is concerned, vis-a-vis 3 subarticle 2 of the treaty. Otherwise, as far as 90 subsection 3 relative explanation 3 is concerned, we may have certain difficulty in understanding the exact import of 3 subarticle 2. Now, what's happened ultimately, therefore, is interesting. Having laid on all of this, what did the Supreme Court do? What did the Supreme Court do? It went directly into the copyright law. It went into all the sections of copyright law, section 14, 16, 18, 30, 31, went into an exhaustive analysis and applied that for the treaty purposes. Now, you went into domestic law directly. Actually, the better way would have been the context has to be proved under 3 subarticle 2. The Supreme Court should have said the context otherwise requires for us to go into the domestic law. Supreme Court did not do that. It went directly into the domestic law definition. In fact, went into the amendments also, regardless of all those amendments have been gone into. Section 9.1 went to all the deletions and additions of the definitions and then gave its verdict concern. Did the Supreme Court therefore act contrary to the principles of 3 subarticle 2? Would be a very interesting way. We have a Mumbai tribunal decision in Reliance Jio, where it has been held that we have to be very careful about 3 subarticle 2. We should not therefore permit through some domestic law incorporated changes have a treaty override concern. Those principles have not been gone into by the Supreme Court, and therefore possibly one will have to await certain further developments on 3 subarticle 2 to go about whether I could have relied upon the domestic law definitions without, in the first place, setting at the context. Supreme Court went otherwise wrong. They say we are using the domestic law definition of copyright. We don't find anything else in the context. Because they say that this definition is not out of context as far as the treaty is concerned. There's a negative way of putting it. Better way would have been to say that 3.2 should have been the better way position. Limit yourself to the definition as existing, because there were about 12 treaties the Supreme Court is dealing with. And these 12 treaties went at different points of time when the domestic law were different. Therefore, possibly you could not have some sort of a uniform conclusion as far as all the 12 treaties are concerned. And possibly, therefore, one could find some sort of may not be a very elegant understanding of 3.2 and the domestic understanding and definition of copyright. The Supreme Court also concerned with the aspect of in respect of. And Supreme Court said, what do you mean by in respect of? It says, it went to one particular decision, Swastik Rubber's case, and then said, in respect of means on. It says, or also attributable. Ultimately, it went on to say in para 103, in also. It began by saying, we are likely to say it is on. Then it went on to say it doesn't make any difference, we use the word attributable. They say they gave some concession, but actually it was the word on. Then they said, we will have no difficulty when we also were to say attributable. And when it gave its final verdict, it says in also. Then they use the word in, on, or attributable. If you start replacing the Supreme Court's verdict in relation to what the law says, it says transfer of all or any rights in respect of a copyright. Transfer of all or any rights on a copyright may not be very elegant understanding. If you were to therefore replace the word on wherever the word in respect of is used, we will not be able to get an elegant sentence concerned. In fact, the word in respect of is also used in section 14 of the copyright law. And if you have to understand therefore in respect of as on, then if you start replacing the word on in place of in respect of, we will not get a grammatically correct way of understanding it. Therefore, possibly we may have to go a word understanding to say it's in respect of, attributable to, in respect of means with the subject matter, concerned with the subject matter particularly. Therefore, it should be in relation, in respect of, could be understood in a slightly broader manner than the very, poor understanding of Supreme Court to say in respect of only means on. It doesn't mean anything else. 2 or 3 small issues before I thought, because I'm now coming, I've already exhausted the time given to me about 10 minutes, 5-7 minutes more. That's permissible. We have to go to goods versus services. Because today the words, whether software is goods, will be a very interesting understanding. This will have implications for us under various sections of the income tax law. We will have equalization levy on goods. If not goods, on services also there is equalization levy. So therefore, goods and services, whether software will be goods or software will be services. That will one way. Goods are the subject matter of 206C1H. TCS is there. The finance bill had proposed 194Q, talking about a TDS in relation to certain transactions and goods where certain limits of 50 lakhs, while purchasing more than 50 lakhs worth of goods, you shall do a TDS at a particular rate on purchase of goods concerned. We have 194O that talks about e-commerce participant. And when he has the transactions in goods or services, he has to do TDS concern. Therefore, we have the aspect of goods or services coming to us at various places of the Act concern. Therefore, we have to understand what do we mean by the word goods. Para 52, para 45, and para 117 of the Supreme Court, 110 of the Supreme Court decision. Para 52, para 45, and para 110 of the Supreme Court decision are veering round to a conclusion that software are goods. Software are goods. And therefore, these are the observations repeated by the Supreme Court. And Supreme Court has made a statement that whatever be the medium of transaction, if I'm buying a physical copy or I'm having a download, the medium or the mode in which the transaction is accomplished is not material at all. Therefore, these paragraphs would indicate that the aspect of goods is now being satisfied as far as software is concerned. Because we're having a lot of problems now. The CGST law has its own understanding. Service tax law had its own understanding. Certain notifications giving you a concession understanding of the CGST with reference to goods, they're not with reference to services concerned. And therefore, we have to understand the word goods. How do you understand? Sale of Goods Act defines goods separately. Constitution under Article 366, sub-article 12 defines goods separately. 366, sub-article 29A defines goods in a separate manner, what Sale of Goods Act would mean. So we have therefore Supreme Court decisions in TCS case, which Supreme Court relied very categorically in this software case also, where therefore, what are the characteristics of goods? You should be able to have transferred, transmitted, consumed, abstracted, used. These are all characteristics of goods, and these are all therefore satisfied in case of a computer software also. Therefore, by virtue of Supreme Court understanding in TCS case, possibly this will be goods. Supreme Court understanding also in the sales tax case, Vikas Sales Corporation also would say that these are goods, and therefore we are moving to a situation where possibly the understanding would be that software shall be goods. Now, interestingly, software is not goods. Then by default, it should be services, what the understanding is. The action plan 1, also the equalization levy and the expert committee report, when they went into those, they said that these two are situations, they are complementing each other. If you are not goods, therefore you shall definitely be services. And possibly, therefore, the new avatars of software, when we have the software as a service, where you have some sort of a mixed contract, a bundled contract, accompaniment of software along with particular services being given to a consumer concern, software possibly is assuming the characteristics of the service itself, and whatever be the law itself, understanding its property, it is movable, it is intangible, then you are naturally satisfying the definition of goods. Otherwise, it's bound to be taken as services. And therefore, in these situations concerned, possibly we have to understand the implications of all these equalization levy, the TDS and TCS provision in the light of this understanding. Pilcom's case, Supreme Court had an occasion to refer to because of the obligations of TDS involved. Supreme Court made a statement in para 28 to 32. There are 4 paragraphs where they said Pilcom's case was dealing with a different aspect, so dealing with payments to non-resident sports association under 194EE concerned. The context is entirely different. Therefore, it refrained from saying anything whether Pilcom's case decided the law correctly, because Pilcom's case said, look at 194 where the TDS obligation is required to be discharged. There's no reference to chargeability. There's no reference to 237A, which talks about rates in force. And therefore, you are bound to deduct tax at source at the rates prescribed under the Act, regardless of the fact that the treaty may be applicable to you and the treaty may give you a lower rate of TDS. Therefore, regardless of that, Pilcom's case said, you shall be obliged to deduct tax at source. Therefore, we are looking at certain observations of the Supreme Court, whether they'll help us in getting over this Pilcom's case in some way or the other. Supreme Court, therefore, in this paragraph said, no, the context is entirely different. But possibly, if we go to para 58 of the Supreme Court decision, there are certain observations concerned. The Supreme Court said that it will be absurd that the TDS is more than the tax payable. It's a little absurd. Therefore, possibly relying on the observations, the spirit of the observations in para 58, we could, in a case available to us, possibly counter the Pilcom's case, along with other arguments concerned that 115 BBA2 says that I'm not supposed to file a return of income. When I'm not supposed to file a return of income means I have to discharge my tax appropriately. Therefore, there's no question of me filing a return of income. Now, when you do a TDS according to 194EE, where the rate is and the treaty is lower, then you're compelling me to file a return of income and asking for a refund, which 114 BBA2 is trying to avoid. So don't have the don't have the obligation to comply with the return filing obligation. Therefore, your TDS should be in accordance with the tax liability. So one can use 115 BBA2, read with section 4, subsection 2, read with section 190, saying that the obligations of TDS cannot be in excess of the primary tax liability itself. And we also have, in the context of the sales tax law, a Supreme Court decision in Bhavani Cotton Mills case, 20 STC 220, to say that you cannot have an extra TDS solely with the purpose of giving a refund to a person concerned, and therefore TDS provisions are not meant to operate in that way concerned, that you have higher tax liability than what is prescribed under the statute and then seek a refund of that. That's not the purpose of TDS law. TDS law should be functioning within the overall charging provisions concerned. Because of the Supreme Court decision, we'll also have the implications on other case laws, especially on databases, Gartner, Giga, Forrester. These have been cases by the Karnataka High Court and Bombay High Court, where they said this shall be royalty, largely following the Karnataka High Court decision in Samsung's case. Now, if Samsung's case has been ruled out by Supreme Court, it logically means that these decisions also, especially Gartner and databases concerned, should be regarded as no longer good law. Therefore, it should help us in allied cases also. Possibly the logic has to extend to images, photo, text, sound, what happens. All this will have to be therefore understood in the light of the rights that the Supreme Court is speaking of and the rights that have to be parted with, exclusivity along with it. All this, therefore, the topic should have to be understood in relation to all of these changes concerned. Then there are certain observations of India's reservations, India's observations concerned. We'll not go into that. What's important for us, therefore, would be the new definition under the UN Model Convention that they have now given a draft out, and they have also asked comments. That becomes a little critical for us because the Model Convention and the definition of royalty says royalty shall now comprise, as far as software is concerned, in 3 limbs. One, they say copyright will continue as it is. Then they say a computer software will be part of copyright. These are under limb A itself, limb 1, sublimb 1 and sublimb 4. They're adding in one more category, limb C in the model definition of royalty to say use of or the acquisition of a copy of a computer program and the payment made therefore shall also constitute royalties concerned. Therefore, they're trying to say that there will be three limbs under which software can now be caught in the proposed definition of royalty under the copyright law by itself, under a specific mention, a separate mention of computer software, and under another important separate chapter or separate line item to say that a copy of a computer software program for use purposes shall constitute royalty. Now, they're also saying that this will give the ability to say that you will attack software in the multiple grounds. There'll be no way of escaping because they're saying software is very critical and we can't afford to lose revenues from out of software concern. They're also making a statement that this will give the ability to the governments concerned, and you have three classifications, to have multiple TDS rates for these. They may not be, there may be varying rates itself. One may have 5%, one may have 2%, one may have 10%. There could be varying rates. Now, this is becoming a little difficult because the model commentary itself is suggesting that there could be some sort of an overlap. One payment can fall under more than one category concerned. It's falling under more than one category, which is an admission by the model convention commentary itself. And we have different rates. How do you comply with TDS obligations is going to be a difficult proposition concerned. The call for comments, and the Indian people have given their comments concerned, but the attempt, interestingly, is that we are looking at some changes in the law relating to the UN Model Convention as far as copyright law is concerned. And therefore, what does the future behold for us now? Supreme Court decision has come. What does the future behold? Will the government accept this and say, this is a wonderful decision, we agree with that decision, therefore we will accept and then say status quo is maintained, this is taken care of by everybody else, and therefore, in my opinion, so the government has reflected its combative moods in the Keynes case, in the Vodafone's case, and therefore, it's given its combative mood. Unlikely that the government is going to keep low. One, what is going to do now? We have seen already that government has moved in different direction. Therefore, there is possibly a sense of a loss of direction. Equalization levy is there, SCP is there, TDS provisions are there, royalty definitions are there. How are we going to go about? We are therefore going to have automated digital services being taxed, a separate rate. How is it going to happen when Pillar 1 comes in? India, the active participant there. Possibly there is, from the government side, multiple attempts to somehow catch this transaction. And what is worrying therefore is, in this somehow to catch this transaction, people will start looking at it in different directions and have multiple levies on the same transaction, because equalization levy is distinct and different from income tax, is what the government is saying. Therefore, they will say, hey, what you've done is equalization levy, I will not accept that. I want income tax act to be levied. If you do income tax act, they will say equalization levy is the correct levy. If you do both of them, they'll say the CGST is applicable. So the problem today is therefore the live threat of multiple levies being attracted to the same transaction, solely because all the governments perceive software to be an extremely important segment in terms of the current business dynamics today, and no government or no country wants to lose its revenue from out of taxing. Therefore, they want to gain the maximum revenue from out of taxing these software transactions. Thank you all for a very patient hearing, and thanks BC again for this opportunity given to go through a very interesting topic and share my thoughts on what is, in my opinion, again, to conclude, a very fascinating and a formidable talk. Thank you.
Thank you, Padam Chandji. For 1 hour and 45 minutes, I did not see you drinking a drop of water. I did not see you any paper as such in your hand. And it was like a marathon presentation, extremely well analyzed. And we extremely are thankful to you for your time, for your expertise sharing. Mayur bhai, you have anything to say?
Only thing is that excellent presentation, and the way Padam Chandji dissected the ruling and dealt with various aspects of the ruling, including the Copyright Act in depth. I think he made the study of the decision very easy. We have a lot of questions, but I doubt that we have any time for dealing with those questions. So I leave it at that and request Suhas to do the needful.
Yeah, yes. With this, I will request Mirbai to propose a very well deserved vote of thanks. Some announcements if you have, please.
I would leave the honor to Rutvik,
Oh,
who
sorry.
has been
I'm
who has
sorry.
been
I'm sorry.
at the back of this. So
I'm sorry.
Rutvik, all the
Just one small announcement that friends, those who have posted questions here, we will note them down and we'll deal with them at appropriate forums, maybe in the study circles or maybe at some other lecture meetings, wherever it is possible. We'll definitely pass it on to our speaker for the day, so that he can also deal with them whenever possible.
That'll be fine.
Over to Rutvik.
Sir, as I think I'll be echoing President and Chairman in saying that probably all of us here have read the decision, pondered over the decision, but until we do not hear your dissection and analysis of the decision, we are all left wondering that what the decision is saying in some aspects. And you have clarified us above and beyond the decision, its impact, its importance. I think my job is made easy because there has been a participant who has also felt a similar way to your to your analysis of the decision, and he has quoted that we all, and I think that he is echoing all of our feelings here, because he said that we all find your deep insights, skill of putting across legality in simple terms with examples, your energy levels and your passion to put across the topic holistically, that is which is very, very admirable. We are very, very thankful to you, sir, that you have
Thanks,
taken out time to study this decision in such a depth and still relay it to us in such simple terms. It's it's a Herculean task, and no one other than you could have done it. So thank you so much for giving us this opportunity.
Thanks.
So friends,
Thanks.
before we close, there is another lecture meeting on similar lines, important decisions to be dealt in, which have come out in direct text field by Mr. Hiro Rai. It is scheduled for 14th of April. Please all join us over there also. And many thanks to everyone here. Thank you, sir. Thank you again for your time.
thank you.
Thank you.
Thank you,
Thank
sir.
you so much.
Thanks.